Mr. Lanphier, why did you not want to communicate with her at all, considering y'all had this vehicle that needed to sort of be worked out?
Trying to communicate about the vehicle led to arguments. She didn't call about the kids. I called her asking her why she wasn't calling the kids, and they led to arguments.
So you were unaware that the car was not
No,
working?
I knew it wasn't getting paid for.
And not
I
working?
gave her the information right away. I gave the bank the information right away. She's responsible for that car, and I'm not.
Okay.
And the conversations were just never good. It got to the point where she was stalking me. I had another report and case about that as well, and it just got to the point where I had to do something to make her stop contacting me.
So the credit union took you to court, you lost, and you were responsible for $3,600.
Correct.
I'm going to open it up to my colleagues.
Did you notify the court that they're going to repossess the car?
Yes.
Did they schedule a reappearance before this judge?
No. It just kept getting turned around into parenting time. That was their main focus.
Well, the judge says, I've got to think about that. Did you give him a chance?
No, he never further thought about it. That was it.
I want to make sure I understand the sequence of events. The hearing took place on May 6th.
Correct.
Correct? And the judge said, I want to think about that some more.
Right.
But then the judge also filed the judgment on May 6th.
Correct.
And apparently didn't think about it anymore.
Right.
You then, when you were back in court for post-judgment proceedings about the children,
Correct.
raised the issue of the repossession.
I did.
And presumably he said, that's already done.
Yeah, it was just kind of like, he kind of was like nodded, and then it went right back into parenting time issues.
Right, which is what you were there for, the parenting time issue.
Right.
Okay.
Did you make an effort to pay it off and then proceed against your wife in some other fashion? In other words, you knew it was going to be repossessed.
Yes, I did.
And they notified you that you would be responsible for any overage that they couldn't pay off the loan.
They did inform me that, yes, it was.
And you didn't take any other action to prevent that?
No. The judge, like I said, told me and her that day that I was no longer responsible for it.
Well, I didn't read that here.
Okay.
And you informed the defendant, at least in July, I see, that this repossession was going to happen.
Yes, she was given all the paperwork right after court. Half of the exhibits were given to her as well, and that was all of the documentation for that as well.
I have nothing further. Okay, we're going to excuse the parties while we deliberate in this matter. Thank you both very much.
Mr. Lanphier, Ms. Acuna, we have obtained copies of your divorce papers from the court in Oregon and reviewed those, including your judgment that's at issue, and we have reached a verdict, and it was unanimous. Let me start by saying, in this lawsuit, we cannot, and really should not, question the judgment of the court in Oregon. It's not our job. It would not be appropriate for us to change anything that was ordered by the Oregon court. Right? This is essentially a case where you, Mr. Lanphier, are seeking damages for what you claim is Ms. Acuna's non-compliance with the judgment. And so where we came up on that is because there's no express assignment of the loan, the only reasonable interpretation is that it follows the vehicle and that Ms. Acuna, you were responsible for the loan. So the only thing we can do with this judgment, Mr. Lanphier, is find that you have enforced it in the way intended. You are seeking the proper remedy here, which is to sue to recover damages that you sustained as a result of Ms. Acuna's noncompliance with the judgment. So for that reason, and given the limited scope of these proceedings, we are finding in your favor, Mr. Lanphier, for the amount of $3,616, which were the damages that you sustained as a result of the lawsuit. So judgment in favor of the plaintiff for $3,616.
Thank you.
And that's our verdict.